Amendment of a schedule and the fourth schedule may be necessary to give effort to provision of law and may also contain such supplement, incidental, consequential prevention, including the provision of the represent the parliament legislation and the state of the states to affect the law. Parliament may be deemed necessary. No such law, aforesaid shall be deemed to be an amendment of the Constitution, the purpose of Article 368. Note on Article 4. Law in the force affect the state of recognition. The effect of organization of states may under the Article 3 and 4 making Telangana the part of the new state of Andhra Pradesh must be ignored under the Article 35b. Hence, Mukti rules continues to force even after the constitution of state of Andhra Pradesh under the reorganization of state 1956. Director of Industries and Commerce and Government of AP Hyderabad Venkata Reddy. A legislative power of state. A state cannot claim to have legislative power over the water in questions. Only Periyar Environmental Protection Form Union of India. They can't have a claim over the power of water. Legislative leave of penalty. State has the power to leave of penalty. State of Bihar versus Industrial Corporation Private Limited. New High Court of State. The power to appoint the sitting of judge and division courts of the high courts of the new states at the place other than the place of principal seat is in the unquestionable domain of Chief Justice. The only condition being that he must act in the approval of the government of the governor. Or Chief Justice can appoint it that be appointed by the governor. The power of Parliament in respect of new state. A power with which the Parliament is vested on Article 2.3, the power of admit, established to form new states which confine the democratic pattern and way ensaved by the Constitution. Mangal Singh is Union of India. Scope and application of Article 4. The effect of Article 4 that the laws related to Article 2, 3 are not to be related as a constitutional amendment for the purpose of Article 368, which means that if a legislation is competent under say, Article 3, respect of the topic, it would be unnecessary to invoke Article 368. Part 2. Citizen at the commencement of Constitution. Who At the commencement of the Constitution, every person who has his domicile, domicile, domicile in the territory of India and who was born in the territory of India, either whose parents were born in the territory of India or who has ordinary resident in the territory of India for less than 5 years immediately preceding such commencement shall be citizen of India. Born in India, parents born in India are resident commencement of 5 years. Okay. Note of Article 5. The determination of the citizenship. The question about the determination of citizenship, even after the limited purpose of certain other laws, has been done by the authority of lie to Constitution provides and the provision of the Citizenship Act 1955. Lal Babu Hassan, which is electoral registration officer. Every person includes a prisoner, a member of armed forces, but subject to Article 33. See the under mentioned decision. State of Maharashtra versus Prabhakar, Sunil Prabha versus Delhi administration, Briti Pal Singh BD versus Union of India. The domicile, how worked? The right to acquire the domicile of birth is available to every person not legally dependent. Not legally dependent. A person can acquire domicile of choice by residing in the country of choice with the intention of the continuing to reside in there indefinitely. Godur Gopal versus Sundar Rahe. One domicile. Under the Indian Constitution, there is only one domicile. There is domicile of the country and there is no separate domicile of state. State Pradeep Jain versus Union of India. Right of citizenship of certain persons who has migrated to India from the Pakistan. Notwithstanding anything in Article 5, a person who has migrated to the territory of India from the territory now included in Pakistan shall be deemed to be citizen India at the commencement of a constitution if he or either his parents or his grandparents who born in India as defined in the Government of India Act 1935. As the case that such a person who so migrated before the 19th day of the July 1948, he has now ordinary resident in the territory of India since the date of migration. The date of such person who has migrated on or after the 19th day of July 1948, he has been registered as a citizen of India by an officer appointed in the behalf of the government, in that behalf of the government of the Dominion of India on the application made by him, therefore, to such officer before the commencement of the constitution in the form and manner prescribed by the government. Provided that no person shall be so registered unless he has resided in the territory of India for at least 6 months immediately preceding the date of application. Notes to Article 6. Catch-up rule as a rule. Catch-up rule. Obligation of catch-up rule are inserted by the concept of consequential seniority code, violating the basic structure of the equality code enshrined on Article 14, 15, 16 of the Constitution. M. Nagarajan versus Union of India, A15. Citizen for foreign state. The Article 9 deals with the case when citizen of a foreign state has been acquired by Indian citizen prior to the constitution, mean that he cannot claim citizenship of the India by virtue of Article 568, State of Uttar Pradesh, which is Shah Muhammad migrated to territory of India. The migration must be with the intention to reside permanently in India. Such intention may be formed even later. Shan Devi versus Mangal Singh. Migration means of movement should be voluntarily and not be a limited period. Kulatti Mamu versus State of Kerala. Domicile on the date of constitution. When an accused under Section 14 of Foreigners Act 1946 claimed that he was domiciled in India and was residing in India when the constitution come into force, then the burden is upon him. He should be given a chance to prove it. Abdul Sattar Havi Bahirim Patel versus State of Gujarat. Right of citizen of certain migrants to Pakistan. Notwithstanding anything, in Article 5.6, a person who has, after the first day of the March 1947, migrated from the territory of India to the territory now included in Pakistan shall not be deemed to be citizen of, shall not to be deemed to be citizen of India, provided that nothing in the article shall apply to a person who, after having also migrated to territory now including a Pakistan, has returned to the territory of India under a permit for resettlement or permanent return issued by or under the authority of law, or every such person shall, for the purpose of clause B of clause 6, be deemed to have migrated to the territory of India after the 19th day of July 1948. Note of Article 7. Citizens of Act. Article 7 clearly overrides Article 5. It is peremptory in the scope and make no exemption for the case of a wife migrating to Pakistan, leaving her husband India. Even such wife may be deemed not to be a citizen of India unless the particular fact bring the case within the provision to Article 7, that is State of Bihar versus Kumar Amir Singh. Scope of Article 7. The Article 7 refers to migration taking part between 1/3/1947 to 26/1/1950. State of Madhya Pradesh versus Mir Mohammed. Person continued to be in India. When a person continued to be in India till July 1950, prima facie, by virtue of Article 5, read with Article 7, he was citizen of India on the date of commencement and continued to be so at the date of offence committed by him in July-August 1951. Mobrit Ali Ahmed versus State of Bombay. Right of citizen of certain persons of India right of citizen of certain persons of India origin residing outside India. Notwithstanding anything in Article 5, any person who are either whose parents or some of those grandparents are born in India, defined in the Government of Act 1935, who is originally resident in any country outside India, as so defined, shall be deemed to be citizen of India if he has a resident as a citizen of India by the diplomatic or consular representative of India in such country, where he is for the time being resident on the application made by him. Therefore, to such diplomatic or consular representation, whether before or after the commencement of constitution, in the form and the manner prescribed by the government of the Dominion of the India or the government of India. I need to read it again. The government may cite a citizen to certain persons of Indian origin residing outside India. Notwithstanding anything in Article 5, any person who are either whose parents or of those grandparents are born in India as defined in Government of Act 1935 as originally enacted, who is ordinarily residing in any other country outside India as so defined shall be deemed to be citizen of India if he has been registered as a citizen of India by the diplomat or consultant representation of India in the country where he is for the time being residing on the application made by him, thereby to such diplomatic or a consular representation where before or after the commencement of constitution in the form and the manner prescribed by the government of the Dominion of India or by the government of India. He is not even there, but there is a consultant if he registered there, and then he will be a resident. That's also the conclusion. Thank you. Tolmach, thank you. Tolmach is, every day 12 minutes constitution we should read, we should understand the constitution. That's our purpose, and this is for you to remember. So every day we read something, we save that. When we require that information, you can read here as a podcast of seeing others video, of seeing our video. You can learn something. That's our intention. Bye, take care.